Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey everybody, happy Friday. I don't know. It's a day. It's a day that ends in Y. The little's right here. She's not happy about having to stay there because she wants to sit on my lap, but no camera time, little one, no camera time. However, today we are going to talk Sarah Grace Patrick. We have the documents. However, Georgia lets me see them but doesn't let me download them, so I will have to log in and do all this stuff. However, PSA, if you don't like my intro, I don't care. And secondly, I only play the Petty Rules intro for What the Hail streams because What the Hail streams and people that are in those streams are the only people that ever tell me how to run my channel or what I should and should not talk about. Also, because I am the name and shame kind of person here, I posted that comment in a group last night in my insomnia state, and someone decided to post, that's because we like Megan and Tug. Okay, fine, whatever. I just really don't care. However, here is the kicker with that. When you are rude to the moderator of the group, who happens to be someone who has supported me since I've had like 2 subscribers, and you get an attitude with them, he will boot you from the group. I went to write this person because I did not want them booted from the group, so I went to write them and apologize for, responding to them, which made the moderator of the group or the owner of the group, admin, whatever you want to call them, see her comment and started the whole reason she got booted. So I went to apologize. However, when I went to apologize, this is what I saw. So be careful, Greta, when you put when people aren't friends with you on Facebook but can see your public thing. I will not tolerate profanity. Probably the reason she doesn't like me. Whatever, I'm not everybody's cup of tea. Rudeness towards myself or others, and especially negativity against my Lord. Here's my problem, Greta Fortenberry. You rudeness towards myself or others, you need to qualify with that with only if I like you. If I don't like you, I have no problem with people being rude to you, as demonstrated by your behavior at like 3 a.m. Also, what the hell kind of Christian are you? Somebody should really talk to your pastor about your activity online, because you can't claim to be a Christian and then act like you do on the internet and then hide behind the fact that you're a Christian. So, Greta Fortenberry, and this is part of the reason that I don't like What the Hale subscribers, is because, no offense to y'all, most of y'all are great, but there are a select few who seem emboldened to say whatever they want because they're hiding behind a screen. Well, here's the thing. I name and shame, and I'm a petty bitch. I will not go out of my way to be petty. That person was ready or petty to me first, so I commented, like I posted the comment. And I deleted I privated yesterday's stream because I gave some information about a case that is close to my house. And when I was going through and like editing to cut shorts, I noticed what I had said, and I'm like, no, 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 no. It's so I'm not going to post the screenshot of her Facebook profile, which is what my petty side wants me to do. So you can see her picture and see that there's a reason that she's hiding behind a screen. Just say. And it's not this it's not this Greta. Like, it's so we, you know. However, I will name and shame, and if you don't like my content, fine. But what happened to growing up and being an adult and scrolling by and not hate watching? It's really not a hard concept. I don't think it's a hard concept. If you don't like people, just you don't talk to them. Seems to work for me. That's why everybody's like, "Did you see so and so?" And I was like, "No, I don't." Um, um, yes, and here's the thing: you personally, because you are practically my neighbor. With that being said, I don't out where you live, and you don't out where I live. With that being said, um, I like my Second Amendment, but I don't want to use my Second Amendment. And we've demonstrated by screenshots and people emboldening themselves to talk shit about other people on the internet while hiding behind a screen and a picture that's probably from like 20 years ago. Also, if I love animals greatly, but grieving an animal isn't a reason to talk shit about somebody online or embolden other people to talk shit about people online. Anyway, getting past our little PSA, update to the channel. I do have an update in the Damon Wilson University of Georgia versus Damon Wilson, the NIL arbitration issue. However, that needs its own stream because Damon Wilson's response to Georgia's request for arbitration, as it's demonstrated by what's in the contract, is like 130 pages. We don't have the time to go through it in this particular thing. Plus, we are talking another Georgia case. The TikTok teen, Sarah Grace Patrick, who is accused of unaliving her mother and her stepfather in their Carrollton home. She had a bond hearing a couple days ago. And this is going back into the Derek Rosa, what we consider someone who's charged as an adult, even though we're a teenager, because she was 16 at the time of the alleged crime. And the crime is not alleged. Somebody did it because two people are no longer alive. It's just alleged whether she was the one who did it. She had a bond hearing, and there is a whole bunch of new documents in the last month, but Georgia makes you pay for documents. Georgia makes you pay for documents if you download them. However, you can go online and look at them. And I just happen to have an account with that particular website. So we're going to go look at them. But we are going to watch her hearing first. It's good. How with you? I'm good. Deeply on serious topic tonight. Let's get on the case. And that's my only derailing. Yes, no reasonable person wants to use them. Yes. The only time I want to use them is like when we go to the range because that's just fun, you know, practice. But just because you have the right doesn't mean you need to use the right. It's another thing. Just because you can say something doesn't mean you should. And when you're messing with a petty bitch, um, it's God's uh like moving on and forgive and forget shit. It's God's job to forgive, not mine. I'm just a petty bitch. Yes, he's talking with himself. LOL, fun. Yeah, he's talking to himself. It's all right. It's okay. I'll out where you live in a house. Uh yes, and if you have not seen JK's thing, I will possibly play it if I can remember at the end of the stream. Um JK took a bunch of sound bites from Spawn and I and made a little collection um of made a little video, as he does, because I said JK might see this and be careful what you say. All right. I look so we did jump rope today and I'm practicing my double unders so you can see my marks. I also I don't know. It's one thing to not like people. It's another thing to just, and yesterday I did go on a little tirade because I've been dropping hints for a year. My mods have full range to time people out for 24 hours if people are mentioned. Um, when I say don't mention what other people talk about on their channels, and people do, other than people here. I'm not going to get mad at someone for asking Spawn how his live went today. If someone is in the chat, I am not Tugs Mods. I don't time people out for just saying hi to another creator like people have done in that chat. So I've heard. However, don't go around and go, well, this person said this or this person said that. Because I just don't care. We just don't care. We just beyond giving a damn. So I'm going to close this door and we're going to start this hearing. Not necessarily in that order. Oh yeah, and my whatever girly hands that anybody thought I had are destroyed between power snatch at 55 pounds, double unders, which I whipped myself, and toes to bar practice, or my weird attempt to throw my legs up towards the bar. Anyway, um, traveling fools, how are you? So good to see you. I hate timing people out, so please don't make me. All right. I'm going to close the door because someone is yelling. Yep. I did put makeup on and I left my hair all natural. So it's still wet. So yeah, it's crazy. And hey Karen, how are you? I agree with Kirby. And that's the thing. I will never say who to watch and don't watch. Like people in here come in here and watch come in here that watch the fleas on a regular basis. There are people in here that watch people I don't like. I'm sure I watch people that, but when you insult my when so the comment for people who weren't here, the comment that was left was your let's see, um your intro sucks. Your intro is utter garbage and it's so obvious you're copying Tug and Megan with the long intro. Is this your first day on YouTube? Like, have you not seen anybody else's channels? Cody, Camelot 331. Love his channel. Especially with PDH. Thank you for streaming with PDH because she's a better streamer than you. I like when he streams with PDH because it's like, thank God. Like, thank God a woman's perspective. Just a little bit too much testosterone on his channel. I love him. He's a friend of this channel. He has been on this channel. But yeah, he gets mad at me. Well, doesn't get mad at me. He jokes around that says when I say I'm just stopping in to drop a like, I'm going to bed. Grab a monster and get in here, otherwise you're fired. Like, that's the kind of friendship. With that being said, his intro is like 10 miles long. And it's like, come on, bro. Come on, bro. I can turn on his intro, go take a shower, and be out, and the intro's still playing. It's like, y'all. Y'all. So, I don't copy anybody. I haven't watched Megan and Tug in a year. Or ever since somebody accused me of threatening them, and I think that was February 23rd is when those screenshots that said "leave me out of your drama" and all of that. That was the last time that I watched. But the only time the Petty Rules intro is played is for those other streams because those are the only people who ever tell me how to run my channel. You know, I danced at Squid's intro. I love that song. All right, getting into this, we have Sarah Grace Patrick. And this is her original trial was supposed to be in the beginning of January, and the day of it all of a sudden got pushed back. So we're going to discuss why, but we will watch this first. And I have this. I'm going to move it to where I can see it. So this is Court TV's coverage. We are going to watch at 1.25 speed because we don't watch anything at regular speed here because, we got more important stuff to do. I usually fast forward intros because I'm mostly on replay cruise more than lives, and that's completely fair. And it's interesting though because intros are not so much for the creator or for the chat. It's for the YouTube's. YouTube is notoriously crappy with sending out intro or notifications on time. Like, take Mo in the Deep End the other day. She does a morning show every day at 8 a.m. Eastern time. Love her morning show. It's the most ridiculous news and headlines you can find. If you don't subscribe to Mo, you should. However, with that being said, I got a notification for her 8 a.m. stream at 7 p.m. a couple days ago. It said Mo is live, and I went back and I clicked on it, and it was like she was live 11 hours ago. So one of the things that the intro is good for is to not only give me time to set things up and get my brain right, but to give YouTube time to send out notifications and people to actually get in here. Because then you get people that are like, I missed the first part. What were you talking about? It just, And hey, Jeff, how are you? All right, we're going to get this started, and I got to close the door. Hopefully.
I have read each of these, and I want to say I really appreciate y'all getting them to me ahead of time. I know some of these are from I think I have two separate grandfathers that wrote a letter, grandmother, several family friends that were in here, some that have been lifelong friends. There were also a couple letters from people that just met Miss Patrick after the incident. There was one that was very kind and said, Judge, I don't envy you and the decision you have to make in the way of that. So that person, I appreciate that as well. I say that just to let you know I did read this. And I picked out one in particular that said that so that y'all know I did read these. And they do matter. No matter what the decision is that I make today, these letters do matter and they have been read and considered. Okay? All right, State, you ready as well?
Ready.
All right, defense, it's your motion.
Thank you, Judge. We are here just for the record on a motion to reconsider bond. We had originally been denied bond back in August of last year, 2025. And since that time, Ms. Patrick has been in custody. I made the court aware of that bond hearing. She was at that time in solitary confinement and still remains in that posture in the Kettle County Jail. So I wanted that to be at the forefront of the court's mind. And with that, Your Honor, we will call witnesses in addition to those letters if the court will so allow.
My understanding is you have 2 witnesses?
That's correct, Your Honor.
All right, call your first witness.
Dennis Nolan Sr.
And I believe this is her grandfather, her mother's dad, the father of the victim.
Yes, sir. He'll come around and then remain standing while reading. You remain standing, raise your right hand. You swear to affirm the statements you make before the court today, the truth, the whole truth, nothing but the truth, so help you God. You may be seated. If you would, just once you're seated, pull that microphone a little closer and speak loudly, clearly in the microphone. And if you'll start off by just stating your name, of course.
My name is Dennis Nolan Sr.
That's going to be good.
Yes, sir.
Thank you.
Good morning, Mr. Nolan. I believe the microphone just went off, so I want to.
Welcome to court audio.
Oh.
She was supposed to already be in trial, and her trial was supposed to be over.
Apparently the other day they had this issue with another court and IT had to come. So just speak up and speak loud for us, okay?
Okay.
All right, Mr. Nolan, how are you related to Sarah Grace Patrick?
She's my granddaughter.
And are you her maternal or paternal grandfather?
Maternal.
Maternal? And so Kristen was your daughter?
Kristen was my daughter.
Okay. Now, Mr. Nolan, have you received, I'll just get to the issue at hand. Do you believe that Sarah is a danger to you or anybody else in this community?
Not at all, no.
Okay. Do you believe that she is a threat to intimidate any witnesses that may be a part of this case?
No, absolutely not.
Have you ever witnessed her threaten anybody or do any harm to somebody that you know of?
No, not at all.
Okay. Do you know if she has a driver's license?
She does not.
Does she have a learner's permit?
Not that I know of.
Okay. Does she have a passport?
No.
Okay. Are you aware of how she became arrested in this case?
Yes, pretty much.
Okay. Did she turn herself in or did the police have to go get
No,
her?
she turned herself in.
Okay. And was that with you or with her father?
Her father.
And is her father, let me ask you this. Were you ever living, was Sarah ever living with you?
No.
Okay.
This is
Do
one
you
of
know
those
if
trials
Sarah
that's
to
going to
have
scream.
any access to any money that would allow her to leave this jurisdiction?
No, nothing at all.
If she is released on bond, would you be a part of the village to make sure she gets back here to court?
Oh, yes, absolutely.
Okay. And where is it that you live, Mr. Nolan?
I live in Rome, Georgia.
Okay. About how far away is that from here?
It's about an hour and 15 minutes.
Okay.
I'm not sure how it
Have you received any money from any publications or bloggers or anything like that in relation to this case?
No, nothing at all.
Do you know if Sarah has received any money from any of those sources?
No, not at all.
Okay, it's like completely side note, but notice the captions and the closed captioning saying Haitians. What is sometimes closed caption is like, say what now? I think she's speaking pretty clearly where closed caption could be a little bit more accurate. But this is another one of those situations where I'm not sure how I feel about her being denied bond. Do I think she did it? 75-25 in favor of guilty right now. However, it's just one of those like, what if she is innocent, and what if putting her in an adult facility in solitary confinement, or this is where Jeff and I will disagree. What is happening to her psychologically where she is pretty much in solitary for months, for almost a year now, and she is ultimately innocent? Did we create a problem because of this? This is another one of those underage people in an adult facility charged with an adult crime, it gets weird.
Do you know if Sarah has any money stored up in some savings account to be able to flee the jurisdiction?
No, nothing.
And how old is Sarah?
She's now 17.
Yeah, Snipe Hunter, people describe it as protective, but protective is solitary, and protective is a glorified word for solitary. And the thing about it is solitary for an adult is punishment. So it's SOP if you're under 18. It's just one of those, is that cruel and unusual because of the innocent until proven guilty issue. It's an interesting conundrum. And yeah.
Did you write a letter to the judge in reference to this case, or to the bond in this case?
Yes.
Okay. And the judge has indicated that he's read that, so I'm not going to have you read it today, but it is a part of what the judge has been turned over. Okay. Do you know if Sarah has ever been arrested before?
No.
No, she has not, or no, you don't know? Okay. All right, that's all.
I understand that, but when you are the only child or the only child in an adult facility, you have no interaction with any other people. If you describe the conditions of quote unquote protective custody and solitary confinement, they look the same to the general person. If you were to ask anybody on the street, hey, what does this sound like? And you were to name specific things about protective custody, it sounds pretty damn much like solitary confinement. It might be for her own safety. However, what is it doing psychologically? And are we creating a whole host of problems when or if people are found innocent that we might not have had before due to being in protective custody? It's an interesting, yes, a lot of possible damage. And that's my moral problem with it. If she was in a juvenile facility, fine. You're in a juvenile facility. Like, you're with people your age, fine. But in an adult facility, pre-confinement separation, it's just, most people wouldn't be able to tell the difference between that and solitary confinement, and that's my moral issue. And I don't think I can change that.
All I have at this moment.
And I have read your letter. I appreciate it.
I need the count.
Good morning, Mr. Nolan. How are you?
Good, thank you.
Good. Now, you and I have spoken before, is that right?
That's correct.
A number of times, 8 times, 6 times, something like that? Okay. Almost always in our office, is that fair to say?
Yes.
Okay, and you've been invited to our office multiple times. You do live in Rome, so you can't always come down, is that fair to say?
Right, that's correct.
Okay, so our office has been open to you throughout this process.
Right,
Okay.
that's correct.
I do want to talk to you a little bit about what you just spoke with opposing counsel on. You said you never lived with the defendant before. Would she be staying with you now in Rome?
No, I don't know.
Okay. If the only way the judge granted bond was for her to stay with you in Rome, would you open your home to her in Rome?
Probably.
Probably. Okay. Where would she be staying? Where would she be staying?
With her best friend, who's her mother's Carrie. I don't know if she's here.
So the defendant would be staying with her own best friend?
Yes.
Okay. And who is that?
Carrie, I'm not sure of her last name.
Okay, Carrie.
Yeah.
Okay. Now, does Carrie live in the state of Georgia?
No, she's just over the border in Alabama.
And I believe we heard from her at the last bond hearing. So she would not be staying in state, is your understanding?
No, it's just, she lives right at the border. So,
And my issue with that, with people going, with the prosecutor being like, she would be across state lines. With certain communities, across state lines is a hell of a lot closer to some people than his house. His house is an hour and 15 minutes, he said, across the state line in Alabama is only like 20 minutes. So, yes, it's technically across state lines, but it's closer. It's closer to the county of jurisdiction, which is another one of those like she'll be staying in a different state. Yes, but staying in a different state would be closer to this courthouse than staying at your house. It's so the way people twist words, and this is one of my criticisms of lawyers. I know it's their job, but this is the twisting of words that I talk about. It's a state line is just a line in the dirt. It does come with different like challenges because it's a different jurisdiction. However, he lives in a different city completely, in a different county, different jurisdiction too. It's like the Kyle Rittenhouse thing. He crossed state lines. Well, yeah, from his mom's to his dad's house was only like 25 minutes. You can be in the same state 6 hours. Like from here to the state line in one state is like 45 minutes and the other state is like 6 hours. So it's perspective. But they yes, I do understand that. And it's just one of those like, but it's also closer to the courthouse for appearances than his house. I just want to know why she's not staying with her father. That's my question.
Sure, understood.
It's what I feel the best for her.
Okay. Now, you were asked a question a minute ago about whether you had sold anything. You were at one point negotiating with media companies regarding the story. Is that fair to say?
That's correct.
Okay. What companies were you negotiating with?
Well,
On crime?
Probably 10 or 15 of them.
Okay.
I don't have a list with you.
Sure. Did you sign a contract with any of them?
Yes.
Okay. Which media company did you sign a contract with?
Lady Well.
Can you spell that for me?
It's LADYWELL.
Okay. Lady Well. Okay. How long is that
Weird. Why would you sign a contract? That's just weird. That's weird. I don't know. Weird.
contract for?
Well, it's for production that will be post-trial.
Okay.
No.
Okay. And what was the compensation in that contract?
I don't recall. I didn't receive anything for signing the contract.
Okay.
There's monies to be paid after the production is made, which would be after the trial.
Okay.
And after the production.
Okay. So it's all on the back end. Okay. What's that amount?
Well, it depends.
That's irrelevant.
Yeah.
It's relevant.
Judge, this goes directly to the family's ability to enable her to leave the jurisdiction. This is something that was talked about at the last hearing, where the family had assets. The court determined she was a flight risk because of those assets. Those assets have now increased by, I'm going to guess, between, I'm not going to put a figure on it, I'll let Mr. Nolan put a figure on it, but if the assets of the family have increased, and that was a concern for the court last time, it remains a concern for the court this time.
I believe Your Honor, the testimony is that it may become an asset in the future, not that it's a current asset. And so it not being a current asset, I believe, blocks the relevance of the importance of the dollar amount at this point.
Judge, there's a significant difference between them selling their rights for $1,000 and some of them selling their rights for $1 million.
Let me ask attorneys to approach. Is this the microphone for your camera?
Yes, sir.
Can you cut that for just a minute?
Yes, sir.
Oops. Sidebar. We're going to
daughter
Okay.
is potentially his daughter. This poor gentleman,
And
what he's
you
going
know-
through.
You know me, I always skip through court TV's bullcrap because Law and Crime at least gives you like the hearing itself, and you will sit there and listen to a sidebar, or you will still be in the courtroom. Court TV likes to do their put their own commentary on it, and we don't like that.
Okay. I think this is relevant area to go into at this point.
All right. I'm going to allow the questions at this time. That was just so the bench conference. That was my concern. I was making sure that that's where each of you were going potentially with this argument. So I'm going to allow questions.
Okay. So I'm going to go back. What is that dollar amount?
What is the total amount?
Correct.
I'll be honest with you, I don't recall because it happened months ago. But I believe it was somewhere around $100,000.
Okay. And is that 100,000 that will go to you? Who will that go to?
Go to whoever the production company feels contributed to the production.
Okay, so that money will be parsed out depending on who participates in what area. Okay,
Correct. After it's all post-trial, post-production.
sure. And who are the parties to that contract? There's Ladywell is on one side. Who is on your side?
Myself, Luann, DJ, and I believe that's it.
And by Luann, you mean Luann Bruce, the maternal grandmother.
Yeah.
And you mean DJ, the biological father of the defendant. Okay. Did they pay any upfront money to you?
No,
No penny at this point. Not a cent has come your way.
No.
It is all on the back end.
correct.
Okay, I sort of agree with the prosecution in part of this, but like you've already asked these fucking questions. You're asking them a different way is not going to change his answer. Move on.
And I want to be clear. It's your testimony here today that none of that money will be going to Sarah Grace. It will be going to Luann and DJ. Is
Correct.
that your testimony today?
That's what I understand, yes.
Well,
That's my understanding of what's in the contract.
okay. It will not go to Sarah Grace Patrick is what you're saying. Okay, understood. Nothing else at this point, Judge.
Anything else?
No, Your Honor, not for this one.
All right, you may sit down. Thank you. All right, call your next witness.
Okay, going to pause it right here before the next witness is called. We'll be right back to hear from Sarah Grace Patrick's grandma. That's right. Kristen Brock's mom is next up.
You can come this way.
One of the benefits of on crime coverage over court proceedings, on crime doesn't really give you their analysis.
Raise your right hand for me. You swear to affirm the statement you make before the court today to be the truth, the whole truth, and nothing but the truth, so help you God. All right, you'll be seated. I apologize for I might be out. If you'll speak loudly and clearly for me, just to help everyone out, I greatly appreciate it. Just imagine that you're talking through a door, okay? All right, and if you'll state your name for the record.
Lillian Bruce. All right, Miss Bruce, how do you know Miss Patrick? She's your granddaughter. Is she your maternal or paternal granddaughter? Maternal. So you are Kristen's mother.
Yes, I am.
Okay. And has Sarah ever lived with you?
I mean, she stayed with me off and on, but no.
Okay. But visitation as a grandmother, that kind of thing. Okay.
5 days.
Let's address this money issue. Have you received any money from any production company, bloggers, whatever, in relation to this case?
Not today.
Not today. Okay. Has there been any promise of money to you in the future for the rights to this and that type of thing?
After the trial, yes.
Okay. After the trial. But at this moment, you have not received any money as it relates to this case. Okay. Do you know if Sarah has received any money as it relates to this case?
Not that I know of.
Have you given her any money from a production company that you received?
Oh, no.
Okay.
I don't know about anybody else. I'm here very tired and lurking. Hey, how are you? Get some rest. I'm just something about signing contracts to cover a trial or the rights to just gives me the ick. I don't know why. Like I understand people have bills to pay. She's got costs like attorneys. Well, she doesn't have attorney's fees. These are two public defenders. But like something about it just gives me the ick. Even like Karen Reed, where I know Karen Reed has a hell of a lot of like money to pay for her defense in both trials. But something about it just gives me the ick. I don't know. I don't know what it is. It's just yeah. I don't know. I don't I can see it in a way, especially if you're innocent like Karen Reed. Oh, you got bills to pay and now you don't have a job. Like you don't have a job. It's you need some sort of income. I get it. It's still icky. Yeah, it is gross. Like it's super ick. Like yeah. Like Karen Reed, I don't know. Even Karen Reed, who I know is innocent because obviously, even the Massachusetts medical examiner didn't or said his wounds were inconsistent with an injury from a vehicle. So, and I just have I have Karen Reed on the brain because Turtle Boy's hearing was today, and I was watching a little bit of that this morning while I was folding laundry, and I was watching Larry's coverage of all the civil the responses to Karen Reed's civil lawsuit. It's amazing. If you haven't checked them out, you should. But it's like, it just gives me the ick. It's just ick.
Do you know if Sarah has a driver's license?
No, she
Does she have a learner's permit?
doesn't. No,
Do you know if she's learned how to drive a car?
I don't think so. They didn't have one that she could drive.
Okay. Does she have a passport?
No.
Are you aware if she turned herself in or was she arrested?
She was forced to turn herself in.
Okay. And when she turned herself in, do you know where she came from?
I think she was at her grandparents.
Okay. And that would have been the same house that's in Alabama. Okay. And where do you live, Luann? Like what city do you live in?
Marietta.
Do you have at this point custody of Jaylee? Okay. And that is Sarah's little sister.
Yes.
Okay. Are you afraid for the safety of Jaylee as it relates to Sarah?
Not in the news.
Okay. Is there any, has Sarah ever made any threats to you or to Jaylee at any point in time, but especially in relation to this case?
No.
Okay. Has she tried to talk to Jaylee or change her testimony or anything like that that you're aware of?
I talk to Sarah every day, and Bailey talks to her when she's here. They're just loving sisters talking to each other.
Have you any reason to believe that she would flee the jurisdiction and not come back to court?
Not at all.
Wait. Okay. Would you be a part of the community and village that would be responsible for making sure she shows up for court dates in the future?
You bet.
Okay.
Yes, ma'am.
Are you aware if she's ever been arrested before?
No, she hasn't.
Okay. And you wrote a letter in relation to this case and this bond this morning? Okay.
I didn't think I was gonna be able to be here.
Okay, right. You had another work obligation.
I couldn't get out of it.
Okay.
The ice changed that.
The ICE changed that. I think it changed a lot of things for a lot of people. But that letter is a part of what the judge has reviewed. And so I wanted you to know that that is a part of it. Now, you are one of the, I guess, victims in this case, right? Would you consider yourself one of the,
I'm very much about to.
okay. And I'm sorry,
My whole family,
your whole family. And you are in support of Sarah
very much,
and her being out on bond.
100%.
Don't think I have any other questions.
Thank you. State.
Judge. Good morning, Ms. Bruce. How are you?
I'm good. How are you doing?
I'm doing well. Again, same kind of starting questions. You and I have had conversations in the past. Is that right? Okay. I do want to ask you just a little bit about those media rights that we've been talking about. How familiar are you with those media rights?
I mean, maybe they're radio, and I've talked to them, and, you know, it's all based on what will happen after the trial.
Sure.
And who they're gonna, you know, make go through all the going pictures and stories and all that kind of stuff.
Okay. And the three people who are involved in that are you, Dennis, and DJ. Is that correct?
Correct.
So the $100,000 or so that we've been talking about, that will get sort of divvied up between that group. Is that right? It won't go to Sarah Grace. It won't go to her sister Jaylee. It won't go to anybody else. That's money that's going to go directly into your pocket if you were participating. Okay.
Creepy.
Now you don't live near here either. You live up north of here, Marietta, right? And you said Sarah Grace has never stayed with you. Is that right? Long term?
Yes. Stayed with me for times.
Okay. She will not be staying with you. She'll be staying in Alabama if she's granted a bond.
Right.
Okay.
Out of our 6-year-old now, that takes up a lot of my space. And
Correct.
employees.
Correct. If the judge were to say that the only way she can get a bond would be to come home with you, would you be able to house her?
I'd make it happen.
Okay.
So when your husband said probably, he was really waiting for you to say absolutely.
Now they're no longer together, Judge. They are.
Oh, okay.
Actually,
He lives in Rome and she lives in Marietta.
No,
But nice try, Judge.
And have you ever been to the house in Alabama where the defendant will be staying if she's granted a bond? Okay. How long have you known this person, Carrie, that she'll be staying with?
I've just known of her. I met her here last time. I don't really know her very well.
Okay, so you just met her here earlier this month?
Well, I guess I've met her.
Okay, this bond hearing is better. The last bond hearing, they threw a bunch of people from church. It was just weird. Like, I'm Christian, don't get me wrong. But like when you overdo your level of Christianity, it just screams insincere to me when you try to act like someone is the perfect Christian. Nobody's perfect. Like that person that I was talking about at the beginning of the stream that wanted to insult me, but um wanted to insult me, but at the same time decided that she put in her profile, "I will not tolerate profanity, rudeness towards myself or others, especially negativity against my Lord." That's someone who screams when you throw your religion at someone so hard, um, and you act like you're perfect. Yeah. Mm. Oh, yes, and Larry is covering, but Samantha Beningo and The Loophole Lawyer, um, are 2 other channels that are covering Karen Reed stuff, and it is fascinating. The Loophole Lawyer does it a little bit more snarky and is convinced that, Brian Higgins was the unaliver and is almost challenging Brian Higgins to sue him for defamation. It's funny. And then Samantha Beningo is a PhD candidate, or I think she's a PhD candidate in psychology, and she goes into a lot of and they've been working together lately, which is even better. I missed the opening rants. Oh yeah. It's I wasn't too mean, but like, and then Baker's been covering all things. But Baker streamed the Turtle Boy trial this morning. Mm.
Some,
At one of the prior hearings,
something like that.
at the prior bond hearing back in August, probably? That sound right? Okay. So you don't know her very well either? Okay.
But I will.
You will? Understood. I'm sure you will. I have no other questions for you. Thank you so much.
Anything else?
Briefly, Your Honor. Ms. Bruce, is it your intention to get Sarah out on bond so that you can, help the production company get footage for their documentary and all of that stuff?
Absolutely not.
Okay.
I'm here for my granddaughter to be free. I think she's unjustly being charged.
Okay, thank you.
Anything else, Ms. State?
Nothing else, sir.
All right, thank you. You may sit down.
Thank you very much.
Yes, ma'am.
All right. Documentary apparently in the works about this case. It is stunning and it's captivated attention all over the nation, as we know. Let's bring in.
There are a couple of things that are fascinating from my medical perspective. So, what fascinates me about this case is the stepfather had an LVAD. So the stepfather had an LVAD, which is a left ventricular assisted device. It is either what people have when they're like, a lot of people who are on the heart transplant list have them, or sometimes people will get them and they won't get a transplant and they will just live with it for life. I worked on a cardiac unit for a while. My cardiac unit didn't have LVADs, but I worked because I was on a cardiac unit when the other cardiac unit, the cardiac surge floor, needed people. The first people that they would take was the people on the floor right above that would do cardiac caths and heart failure and all that. So I was LVAD certified. You have never heard an LVAD alarm? It is loud. It is loud. And even though I was used to working with them, even changing from wall power to battery power, the alarms would go off. And it is the most like anxiety producing sound that I've ever heard in my life. So the fact that his LVAD device was going off and no one in the house heard it. Sarah said she didn't hear it, and I understand tuning it out, but when it is going off for an extended period of time, it's almost like an alarm clock where like, okay, Mr. Squid's alarm clock goes off and I don't wake up. However, if he doesn't wake up and his alarm clock keeps going off, I wake up because I know there's an issue. To not wake up to the sound of an LVAD alarm just makes me question things, because I've been around LVADs for years. It's one of those things that just doesn't add up in this case to me, having had the experience of actually working with an LVAD and being paranoid about if I'm working with this patient and their battery dies, we have to get them changed before I unalive this person unintentionally. It's one of those things that, like, even though I was rehab and I wasn't a doctor or a nurse, you still have people's lives in your hands. And it is just one of those things that I will never be able to comprehend how someone cannot hear that, because after someone expires, that LVAD will alarm because they are not getting the input from the body. Uh, And and basically the LVAD's not working because it's gonna be like, "Okay, there's a problem here." So it will alarm to let you know that there's a problem. And the fact that no one heard the alarm. Yeah, I know that sounds it all so well. It's annoying, and it's meant to be because it's a life-saving thing. When that alarm goes off, there's a reason for it. You need to fix what the alarm is. Usually it's the suction alarm that goes off. So I'm assuming the suction alarm was the one that was going off because obviously, y you know, just if you know heart anatomy. But it's one of those things that from this case, it I just can't get over. So we're gonna skip ahead again.
Right now, in the courtroom is the question. We'll be right back.
Your Honor, we believe that Ms. Patrick is in fact a good candidate for bond. I think that on the last bond hearing, the court heard from Ms. Bowling, who is the sister of James Brock, and her statements were of impact. She came up, she was emotional and teary-eyed, but the fact of the matter is that she is, as I told the court, only one side and one person of this victim family. I use the air quotes because, again, it seems as if to counsel that Ms. Bruce and Mr. Nolan are not being treated with the same gravity. Their words and their support for Sarah is not being treated with the same gravity as the other side of this, when in fact they are of closer relation as mother and father to the deceased than Ms. Bowling would be to her brother. And them being in support of Sarah, I think should hold with this court more gravity in ways because of the close relation of them having birthed the deceased. Not to discount the emotion or feeling that Ms. Bowling may have for her brother, but that is a closer relation. The risk, the four factors that the court has to consider is that is she a threat to the community, a threat to witnesses, risk to flee, risk to reoffend. The state wants to say that, oh, there's this influx of money and so she's gonna run. That, Your Honor, is at fault in the argument because none of that money belongs to Sarah. None of that money, she again is 17 years old. She's not an adult. She doesn't have a bank account. She doesn't have a driver's license, a passport, and they don't even think she knows how to drive. And not that Miss Bruce is aware of that she was even taught to drive. They didn't have a car for her to learn how to drive, was the testimony. And so her being a risk to flee, I think is totally unfounded in that she turned herself in voluntarily from Alabama. I think the state is going to argue to the court that she won't even be in Georgia. The court heard from Ms. Jensen on last bond hearing, so I didn't bring her back up, that she does stay right across the state line, and her house is where she came from voluntarily to turn herself in and be at the mercy of the sheriff's office and this court. And so I don't think that going back to Alabama would be a problem at all. It is a part of Ms. Jensen's letter that is a part of what has been turned over to the court, that she would be welcome there. We as a group, I've spoken with the family and with Ms. Patrick about where would be the best option for her to stay. I will say to the court that I have a list of some odd 15 people where she could reasonably stay. We have, as a group, considered all of those places and what would be the best course of action for making sure she gets to court, having a stable environment, being in a place where she could be away from the media frenzy that I think will surround her here in the immediate area. And so we just made that decision that Ms. Jensen's home there in Alabama, where she's already comfortable and would have the ability to stay off of social media, be somewhere where she wouldn't have the need for a phone and that type of thing, which I would ask the court to make that a part of the conditions of her bond, that she not have access to social media and a cell phone of her own. And that home just landed as the place that I think had all of those things encompassing, and a place where she would be comfortable. But that's not the only place that she could go. Your Honor could order that she stay here in the Carrollton area or in the surrounding area, and she has those places available as well. Several people have said that they would make sure that she has a place to stay and that she is housed. So her going to Alabama, I don't think should have that much weight from the court as a cause for concern. As it relates to a threat to the community, the people who are victims have said she is not a threat to them and a threat to witnesses. She is not a threat to them. She is not a threat to Jaylee, never has been and never will be. And so the people who are closest to her, who talk to her on multiple occasions throughout her life, not just somebody who started talking to her after the incident happened, but they have said she is not a threat to the community. She is not a threat to witnesses. She is not at all a risk to reoffend. When we look at the risk to reoffend, I think that generally the court looks at a person's criminal history because we know past behavior is indicative of future behavior. She's never been arrested. That was presented at the last bond hearing. She still has no criminal history, hadn't had any incidents in the jail or anything of that sort. As a matter of fact, I think she is thought of and spoken very highly of by many of the guards there at the jail.
Well, here's the thing. So look at if you actually look at the name of the video, it kind of gives away the end result. So, this is a so much better idea for her to get out than that adult prison. I am torn because I understand wanting to keep what the prosecution and the state may view as a violent person away from the general public. However, she is 17 and we do have an innocent until proven guilty society. So I'm like, I'm very torn. I'm very torn. And this is one of those situations where I look at the long term because not everybody who goes to court is going to be found guilty. See Kyle Rittenhouse. How much psychological damage? Kyle Rittenhouse is another one of those cases of under 18 at the time in an adult facility, not allowed to get out. What damage did we do as a society keeping someone? It's my psychological side says, are we creating? We have a mental health problem in this country, but are we contributing to it in situations like this? Are we adding to the problem when we're supposed to be keeping people safe? Are we making it worse? Looking at the big picture, are we making it worse? It's an interesting argument, and I can see both sides of it. This is where Jeff and I, we agree to disagree because we will never see completely eye to eye just based on background. I have a background in psychology and therapy. He has a background as a law enforcement officer. We come at this with different perspectives because we've had different experiences. But yeah. So they need to ask, did she do it? And then if found guilty, then her age should be taken into account. That's how I see it. Until she's found guilty, her age should be used for the facility. I think she should be in a juvenile facility. There are different classes of juveniles. There's a difference between a person who went on a joyride in a car and who was accused of unaliving someone. but she'd still be in an area with people closer to her age. Psychologically better for her. Also, we learned in juvenile facilities better access to education because of the fact that those are kids. Everybody under 18 generally goes to school. Adult facilities, those people are over 18. They've either didn't graduate or they've graduated and they don't need any more education. It's just it's a weird conundrum. So in his case, though, attorneys actually put up the bond to the overall circumstances of his individual case. And hey, King Paco, how are you? Though you're right, they don't know why she snapped if she did it. I think she should be in facility. I don't think she should be in an adult facility.
Your Honor, we have presented to you 21 character letters, 21 people who are willing to vouch for that young lady sitting in that chair. 21 people.
I agree with
Okay,
that.
gotta hand it to defense counsel delivering some really passionate arguments on behalf of her client. No doubt, Sarah Grace is in excellent hands here, but will she be able to go home? That's another question. We'll find out together live next.
That attorney is a public defender, so she's a really good public defender. I kind of agree with her arguments. I don't hate them.
I think that is something that the court should. People who are going to run generally don't have that type of support. People who are going to abscond from justice generally don't have that type of support. People who intend to not come back and not do the things that they're supposed to do not have this type of support, Your Honor. I think that is something that the court should look at in a major way as to the risk to flee. Is that when you have connections and ties, not only to the immediate community, but just to a community in the aggregate, that is what keeps people accountable. And essentially, bond is for there not to be any new crimes, which she doesn't have any indication that there will be any new crimes because she doesn't have any criminal history. And
Hey, Rhinestone Wow Girl. Hear from Mo. I love Mo. Mo is the sweetest. And the funniest, too.
maintain her innocence, that she has not done this that she is accused of, but also that she just has the vast support of the community around her, and that they have said they will hold her accountable. That is a part of the letters as well as the testimony today. Again, as it relates to the money, Your Honor, if there is this vast influx of money, Your Honor, I'm sure would not grant a recognizance bond. There would be a monetary amount to it. So any money that...
And to the Mo Raiders, we are watching the Sarah Grace Patrick. Sarah Grace, and I just got raided too. The Sarah Grace Patrick bond hearing from a few days ago. This is a case that Mo has talked about covering. This is a Carrollton, Georgia teen who is accused of unaliving her mother and her stepdad at 16 years old. She was denied bond last year. She was supposed to go to trial in January. Well, that did not. Excuse you, ma'am. This is so y'all. This is what's going on in my house right now. Angel, no, sit down. No. Yes, please. Oh, no, sit down. So yes, baby squid raid. y'all raided the chat. She raided the room. We are watching the bond hearing from a few days ago, and after the bond hearing is over, we will be going through the documents that have been filed in the last month. Georgia doesn't allow me to download them unless I pay for them, but I do have access to look at all of them. So we will be going through some of them.
There is that I think that the family has come into the way that the state wants to portray it will be going to that bond, I can assure you. And in addition to that, she is indigent. And if there is any other monies would be going to the hiring of an attorney, I would assume if they could afford that based on this sudden influx of money, which the testimony has been, is that no money has been given to Mr. Nolan or Miss Bruce, and that everything is post production. as it pertains to the veracity of their statements, Ms. Bruce was clear that they're not trying to get her out to, have her do interviews or anything like that. As a matter of fact, Your Honor could order that she not have any of those contacts or any of those interviews until after the trial. There is case law. I was not able to look it up because I was trying to pay attention and question, but I am certain that there is case law that, as a matter of fact, the defendant cannot profit off of books or publishing rights and those types of things as it relates to their case. And so I'm not sure if Your Honor is aware of that, and I can find the site as I continue to look and present that to the court if need be. But Your Honor, she has a place to stay. If Your Honor would require that she stay in Georgia or stay around the area, she has those places as well. We could provide addresses to the court. And so we're asking that Your Honor would grant a bond in this case. She is in solitary confinement as a 17-year-old. The courts have acknowledged that solitary confinement on juveniles is, even though she is being charged as an adult, she was at the time of the incident and is now still a juvenile, that it has vast implications on the mental health of persons, not just juveniles, but persons in general that are in solitary confinement. So I'd like the court to consider that as well. We filed.
Just remember, solitary confinement is viewed as a punishment for an adult in Gen Pop when they fuck up. Just saying. So to automatically put a teenager under the age of 18 in solitary as protective custody in an adult facility, the mental health repercussions of that, I'm having problems with.
This bond motion, Your Honor, because of the pushing back of the date, which was no fault of Ms. Patrick's.
Okay, and that has to do with the evaluation that just has.
And we skip past this. We will get to the documents. Court TV, sorry about your coverage, but I don't care what you have to say. If I did, I would have watched this without, not on my channel.
Accused of murdering her mother, Kristen Brock, and her stepfather, James Brock.
Months or so where we're going to be waiting, I think, is a factor that I think the court should consider in weighing whether or not the court grants bond today. But we would ask that Your Honor would grant a monetary bond with conditions. I am specifically asking that Your Honor would grant the condition that she not be allowed the use of a personal cell phone, that she not be allowed the use of social media. Your Honor has tools in his toolbox to say to keep her confined to a particular address. She can be on ankle monitoring, house arrest, with not the ability to go out and socialize or do any of those things. We now have the technology of GPS monitoring, so it's not just, are you at home? They can tell exactly where you are. So if there is any question about whether she'll be out, being a threat to witnesses or the community at all, she could be closely monitored and will be closely monitored by her family. So Your Honor, we're asking that you would grant a bond in this case with the conditions that she not have any contact, of course, with witnesses, that she not have any contact even with, the Mr. Brock's family, if that is a concern, and also that she be on house arrest, ankle monitoring, GPS monitoring, so that the court will be aware of where she is. And I have no doubt that she will show up for her court dates. She is eager to assert her innocence. And so, Your Honor, that is the ask of the defense at this time.
All right, thank you. I want to say, Ms. Mitchell, if you'd like to come grab a seat, you can. I also did observe you help that young man in the back of the courtroom. Did you get him where he needed to be? All right, so. Okay, Madam Clerk, can you hand her what she needs so you can go ahead and be productive? But I did look over there. I appreciate you helping him out. You could tell he was stressing. He didn't know where to be. So, thank you. All right, Mr. Ferris, you ready?
Thank you, Judge.
All right, come on up.
Judge, the state does oppose bond in this case. You've done enough bonds with me to know I follow a particular protocol when I go through my bonds. I always start with the case history. We're talking about an incident date of February 20th of 2025. That is less than 12 months ago. An arrest date on this case was July 8th of 2025. This case went before the grand jury August 19th of 2025. And we had a bond hearing on August 19th of 2025 as well, which I'm going to talk about in a minute. The trial court date on this case is set for August 3rd of this year, which is less than 1 calendar year from indictment. That is incredibly fast. Opposing counsel did mention the additional time based on the continuance that for all intents and purposes had to be granted. That is not a consideration for the court. The court's structure in regards to this is pretty straightforward. There is no material change in the circumstances of the defendant. That's where we are. I'm going to read from that bond order on August 19th of 2025. After hearing evidence presented regarding the defendant's motion for bond, this court finds the defendant is a risk to flee the jurisdiction, not appear for future court appearances. The defendant is a risk to influence witnesses. The defendant is a threat to the community and family members as testified to at defendant's hearing regarding bond. Through all of the testimony and argument we have heard today, there has been nothing to dispute that fact. If anything, I think it could be argued that the flight risk is actually more significant now than it was before. The family in this case does oppose bond, Judge. And one other thing that I do want to address that was at the beginning of opposing counsel's argument. Our relationship with both sides is as much as we can make it. Miss Bruce, Mr. Nolan, and and DJ, the biological father of the defendant, they have been invited to our office constantly. Anytime we have spoken to the Brock side, we have reached out to the other side as well. They choose not to come. I sat down on that August 19th, 2025. We sat up in our brand new grand jury room up on the 5th floor, and I sat and answered their questions for at least a couple hours. I think it was about 2 hours that we were up there. They have been asked to come in every single time. I am inviting them to come into our office to talk to me today, tomorrow, any day, anytime. I cannot make this more clear. Anytime they want to come in and talk about the case, I am available to them. If they want to, we can set up a conference call on a weekend. If they need me to drive up to Marietta or up to Rome, I will drive up to Marietta or I will drive up to Rome. I drove up to Marietta a couple weeks ago with my investigator. Miss Bruce was actually not there. So we have tried our very best to have a good relationship with them. They have turned their back because they do not believe that we are prosecuting the right person for this case. That was something I told them from the very beginning. I'm going to be as open and inviting as I can be, but we are not going to agree on that fact. They choose not to come in, Judge. I have conversations on the phone with Mr. Nolan and with Miss Bruce because they live far away and it is difficult for them to come in. Any person in that family who wants to come in and talk to us can do so. At that meeting on August 19th, I told them to bring as many people as they want to. Friends, family, whoever they'd like. I invited them to record the interaction if they would like to. I have no problem talking to them. The state is not scared of talking to the family on either side. We invite them. Going back to the Brock side of the family, Judge, I do have a statement from them. They oppose bond as well for the same reasons that they opposed bond in the first time. I would like to read this statement from them if I could. The seriousness of the charges before this court cannot be overstated. The accused is being held and charged with the malice murder of 2 people. These were intentional violent acts that were permanently destroying our family. Granting bonds in a case of this magnitude would undermine the gravity of these crimes and the devastating harm that she has already inflicted. Then they move to addressing the Ayala factors. We remain deeply concerned about flight risk. The defendant is facing the possibility of life-altering consequences if convicted. Given the severity of the charges, the incentive to flee is substantial. The immediate family has the resources which would enable her to flee. Her family maintains that she is innocent, and given her manipulative behavior, it is possible for her to flee. Once released, there would be no meaningful way to ensure the defendant remains within the jurisdiction or appears for future court proceedings, since family and close friends have homes outside of the state of Georgia. We are also gravely concerned about witness intimidation. This case relies on witnesses who must be able to cooperate freely and safely with law enforcement and with the court. Releasing the defendant creates a real and reasonable fear that witnesses could be intimidated, influenced, or discouraged from coming forward. Even indirect contact or perceived threats would be irreparably damaging to the case. Finally, and most urgently, we fear for our own safety. The loss that our family has suffered has traumatized us and left us vulnerable. The thought of the person accused of killing them being released into the community causes us constant anxiety and fear. Bond would not only endanger witnesses, it would also place our family under continued emotional distress and fear for our physical safety. The accused is being charged with 2 malice murder counts. These are horrific and violent crimes in which she is being accused. The defendant's second bond request, this is the defendant's second bond request, and nothing has changed that would justify reconsideration. The risks remain the same, if not greater, as the case moves forward and the consequences become more real. Our family would not be able to sleep in peace knowing that she is not in protective custody. Judge, it's the state's position that on August 19th of 2025, she was a poor candidate for bond, and that as I stand here before you today, she remains a poor candidate for bond, and bond should be denied as such.
Who made the statement?
That was crafted by Kim Bowling on behalf of the other family, the Brock family.
Who was that for? Who made the statement?
Kim Bowling.
No, that's the sister.
It is.
No. At the past hearing, we also had a brother testify. Is that right?
We did, Judge.
Right.
We had sons. We had sons and her, and then a friend of the family as well, if I recall correctly. It's going back
The
a
last
little bit.
bond
I believe
hearing
it
was
was
long.
her brother, stepbrother. Is that correct?
I think so, Judge.
Is that right?
That's right.
And he was not in favor at that time as well, correct?
Correct, Judge. There's significant numbers on this side as well.
And they lived together for a period of time, correct? The brother? That was my recollection, that he was in the house for a period of time. Is that not correct?
Not in recent memory, Judge, not in recent history, is my understanding.
One of the issues that I have with this case is the interview that the grandfather gave to Law and Crime shortly after she was arrested was bizarre. The interview that the father, the biological father, gave to Law and Crime shortly after she was arrested was bizarre. Why the victim's parents are on her side is another psychological mystery. And I'm not diagnosing anybody with anything. That is not my job. I just like to know, like, I have this brain book back here. My brain operates in what makes people tick. And is it because she's a teenager and they can't believe that their granddaughter would do something so awful? Or do they truly believe she's innocent? Or are they have blinders on because she's a teenage girl? And we don't like to see teenage girls as awful and horrible people. It's it's tricky because we do have this innocent until proven guilty. However, her behavior was just bizarre. Going on TikTok and asking for people, she was reaching out to TikTok true crime creators to help investigate this case. It was weird to them. And they're probably used to being reached out to. I mean, these are massive creators on TikTok. I'm not on TikTok. I don't use TikTok. I don't know. But also her TikTok where she was crying seemed staged. Yes. It's taking a little to the bathroom. So it was just weird. Like, it's so odd. It's a psychological conundrum that I just don't know if I can get past. And there is no right answer. It's just weird. I'm just curious of why the grandparents are so adamant that she is not the person who did this.
All right. Anything else from the state?
Nothing else on the stage, Judge.
Okay, thank you. Anything else, Ms. Williams?
No, Your Honor.
All right.
All right, there it is. The arguments are in. It's up to the judge. We'll get a break and find out what the judge decides. Should Sarah Grace Patrick be able to go to Alabama and hang out with her buddy, or remain in jail before her trial? Stay with us.
Yeah, that is weird though, staying with a friend. You should be staying with an adult you're related to. Whether the cross state lines issue, the fact that it's only like a half an hour, 45 minutes versus a couple hours. She is underage. She is still underage. She should not be hanging out with her best friend. This should not be like an easy ride. Like, you should not be hanging out with your best friend or staying with your best friend. You should be staying with an adult that you are related to. I got the feeling she did it so she could ask them to investigate my yeah, it is. The grandparents are in denial, but if proven guilty is the thing. Yeah, that's the yeah. I mean, this is a bond hearing, but if you look at okay, I'm going to go back to here. If you look at the title, accused double murder, Sarah Grace Patrick denied bond again. So it's like, spoiler alert. However, it is one of those things of it's interesting to watch. And but I think she should be in a home facility out of prison, not with a friend. Yeah, you need to be with an adult family member, grandparent, aunt, uncle, cousin, not a your best friend. Just weird. But all right, let's get into where the judge makes his decision.
To affect the other factors. But just because certain parts of the family want her out, that doesn't mean the judge is going to do so. And I would venture to guess that the judge, because talk to anybody, I'm a person. So I think at the end of the day, I don't think the judge is going to be giving bail.
And find out what the
letter that I referenced before I got started, when she said, I truly understand the difficult position this bond hearing places before you and deeply respect the weight of your decision. I didn't realize I was actually going to be referencing hers at the beginning, but that's who Ms. Jensen is the one that wrote that.
That is true too.
All right. So in preparing for this hearing today, I was prepared to listen for and hear anything that showed that there was a material change. As of right now, I don't see that there has been a material change. The only real change that has happened, one, is the court date change. And then two, I don't believe I had the information in front of me that family members had signed contracts with different media companies at the prior hearing. So that's new material. When I look at this, when I asked the state and defense to come up, when the witnesses were testifying, when defense objected to the line of questioning the state had, my concern was I wanted someone to ask or bring up the question of the veracity of these statements, because while I know, and I hope the family hears this, I'm not doubting your love for your granddaughter or your daughter. Is Mr. DJ here this morning? That's not in question. Okay, and I think I said this last year. So whatever ruling I make today, do not think that it is me determining your love and care for your daughter, right, or your granddaughter. With that said, I do have to consider some of the things that have changed, and with these type contracts, if she were to be released, y'all could benefit from your Ms. Williams actually used the term media frenzy. The more that's brought about, potentially the higher or more you as individuals would receive potentially. And so while that's not an IALA factor that I have to evaluate, that is some of the change that in consideration of where she's going, who she'd be with, and they play into the factors of what could happen. But again, that does not play into whether or not you care or love your granddaughter or your daughter. All right. Going to the court dates. I don't believe that really goes into the material change argument, but it is a change in dates. And I want to lay this out. Ms. Patrick, I tried to take some time with you last time going through the arraignment process and the going through the grand jury. So I'm going to lay this out for you today, okay? A typical criminal trial that most people don't realize, for that to be fast, for a criminal trial, especially one like this, a murder trial or child molestation or rape trial, these heavy crimes, right? Most people in the judicial world would say that 1.5 years is a really fast track for that case to be heard. And I'm sure your attorney's probably gone over this with you some. You're even shaking your head yes, like you understand that to be the case, right? So right now, when your case first came up, the first court date that I gave you, I was trying to push because I know your age, right? And I wanted everybody to understand by me giving those first dates, do not drag your feet. But in all candor, if you remember, if you go back to that hearing when I set that date, I kind of had a little caveat saying, I understand this may be pushing, right? And what happened was, as we came up, defense, you announced ready, but in actuality, you didn't even have your full report. And to do that, you would have needed that report. If we had started that day, you were thinking you might have the report by Friday, but you weren't sure. But I think you did what you had to do in the moment, say you were ready, but you were announcing ready without the full report that you truly need. State needs that report. They need that full report to do their job and have their experts. So as both of you stated that day, and I believe the state even addressed here today, the continuance had to be given. The continuance had to be granted.
There was also some issues with the parents and reported street pharmaceutical use. I have not been able to find anything. Google searches, background checks to see if that's real. I don't know. Nothing's been. Everybody's been kind of tight-lipped about this case, which is another thing that's odd. Usually, you get a whole bunch of people talking. The state releases stuff. The state has been. If the state of Utah acted like this in the Charlie Kirk case, people would be flipping out even more than they are and coming up with conspiracy theories because the state has not released crap. So it none of this adds up. It's all weird.
For fairness to take place, right? Fairness for you and your attorney to actually get the full report, in fairness for the state to be able to prepare for this case. Now, in doing that, I had a couple of different dates available. The state and defense both came to me and said, Judge, we know that you don't want to move this case again. We want to put it on your August date. That was the date that was agreed on by defense and the state. If I look at the dates, right now, we just acknowledged, and you were shaking your head yes, as if you understood, that a year and a half is really fast for these type cases. That's typically as quick as one will get, right? If I look at my dates now for your August date, you hit right at almost exactly a year and a half. So even with that August date, your case is still moving at an incredibly fast pace. Do you realize that? Now, with that being said, state and defense also know I do not want to continue this case again, right? And we're going to do everything that I can. I'm going to do everything that I can to prevent this case from being moved again, right? It's my understanding there may be some changes that take place. If those changes do take place, I do anticipate signing an order to specially set this. If there are conflicts, I commit to both state and defense. I don't mind calling other judges that may have conflicts and ask them if they don't mind if we jump ahead in line so that I can have attorneys report to me so that we can make this happen. Right? And I hope that we can do that. But when I look at this again, I think the state's correct. I have to evaluate it for material change. I don't see much of a material change. The risks that were there at your first bond hearing still exist. I do have to say I can see both sides, but I do see from the state saying that things may be even intensified with these contracts, because that brings a whole level again of motivation. If you're out, what's going to motivate you or that side to do things? Because the more that's there, the more they have, the more potentially they get. That's a risk too.
Oh, I didn't even think of that. I didn't even think of that. The more that they have to film, the more money they get. That was an ick factor that I didn't even consider, but this judge did. And that's why he's the judge and I'm not. Just one of many reasons.
Based on that, and based on evidence that was given to me at the prior hearing, I believe any time that I make a ruling that takes into consideration statements that were made at prior rulings, I have to place that on the record. So I am placing on the record that part of this ruling is based upon the testimony that was given to me at the prior bond hearing, okay, and statements that I heard then. And I'm not giving more weight to one side or the other. That's just not the case. What I am doing is properly weighing this to the best of my ability against the law, right? And that's what I have to do with these factors, right? Based on doing that, I am going to stand with the original order that I gave. Bond will continue to be denied. I do not find a significant material change in circumstances or facts that would allow or require me to make a change in that prior ruling. So the prior ruling will still stand. All right, and your case is set for August 8th. Attorneys, we will continue our meetings as we've done prior to this. I anticipate us still having our monthly conference calls to make sure that we can stay on pace and stay on track. If there's a change, please let me know if there's a change. And whenever that change is made, I will continue to bring that person in to continue with these monthly conference calls so we can keep this case on track. All right. I do want to say again, Ms. Williams, you and your staff and the state, y'all have done a fantastic.
All right. With that being said, that's kind of the end of it. The judge is putting both the state and defense on notice. They set trial, no further continuations. I think he would like to extend it out a few more months. Well, and here's the thing. Speedy trial is not really speedy, but does saying no further continuances kind of give a Judge Arthur and the I can see that girl's name. I can see that girl's face. Carly Gregg trial was a 14-year-old accused of unaliving her mom, convicted. But does that give, if she's found guilty, the defense a possible means of getting the verdict overturned and appealing because of the fact that they rushed? It's seen both sides. Like, I'm not a lawyer by any means, but part of being good at arguments is being able to argue both sides of a situation. Debate class in high school. Everybody's done a debate in high school, whether you're on debate team or you just had to argue something in a class. Part of one of my teachers was like, part of being good at debating is being able to argue both sides. I can't imagine that being a lawyer and having to argue all day, that being able to argue both sides would be quite important. Um, it's just the judge wants to make sure justice is served, and there's no reason to look back and say he didn't give her a chance or didn't give the state a chance to prove their case. I know, but does rushing to trial become an appealable issue? It's one of those things where, like, it might be a thing. I'm not saying it'll work. I'm just saying, could it be a mode of appeal? And eh. Speedy trial forces a 70-day trial. Waived speedy allows both sides to extend it out. Well, and it's just a matter of, like, because this trial was supposed to be over by now. This trial was supposed to be done and over with, back in the beginning of the month. So I am going to close that, and we are going to go to logging in, party name. I will show you what I am looking at. So we will go to here, share screen, and this is what I am seeing. This is Carroll County's docket. All right, so it's this one. All right, I have to go 12/3, 12/11, 12/15. We covered everything up until like 1/6 because her original trial was supposed to be 1/6. So we will cover everything from 1/6 to now. 12/15, 12/23. I'm just making sure I get it right. I looked at it earlier, but I can't download any of these documents without paying for them. Really, in what world is a year and a half not a long time? Only in the court is it a short time. Court system, it's all right. So this was the so people have requested to rule a recording device, all of that, the 6th order for recording device, all of that stuff. They haven't really, this is where I'm saying, like, nothing's really been filed in this case. Like, I know these are small and hard to see, but this is a request to use a recording device on 1/2. We had seen these because this is all the way up to her trial. And party notice, printed court event, non-jury court date, 27th day of January. That was 2 days ago for this hearing. But there's been nothing more requests to record proceedings from different parties, Ladywell Films, Court TV, and then the order denying bond. Like, literally, there has been nothing filed in this case. 124 entries in a year, and most of them are orders from the judge for different entities. But, like, we will see what they used for motion for immediate bond reconsideration. This was the oh, come on. There we go. There we go. So this was signed January 5th. Its calendar call was scheduled for December 16th, in which time the defense announced ready for trial. At said time was a pending report from a defense expert. Defense verbally and in writing notified the state of its intention to present expert testimony in the area of forensic neuropsychology. The trial was further scheduled for January 5th. Defense again announced ready for trial, with a preliminary report having been submitted, and the state made a motion for continuance. The court granted the state's motion and further gave an anticipated trial date for August 3rd. It's just a yeah, like, not the state has been super tight-lipped. They have this mountain of evidence that they claimed from the very beginning in all of their press conferences and all of that. They have this mountain of evidence, and that's a quote. And, "Hey, Heather, how are you?" But it mm, it ay, ay, ay. I mean, and I give her attorney credit. She is doing everything possible to figure this out. However, motion for immediate bond reconsideration, like, the court orders parties above reference to appear before Justin Hightower, 27th day of January. That was this hearing we just watched. It's like nothing about presenting evidence, nothing about discovery requests, not a damn thing. And this is just odd. So this was his 6th order. Come on. 6th order on request to record. They wanted to record the hearing. Law and crime shall be pool reporter and shall allow no more than 1 camera, 1 microphone, and 1 recorder. Like, it's like the judge has filed more stuff than any of the lawyers. It's so bizarre to me. Like, Rule 22, law and crime. Request to use a recording device. It's just so. It's like the judge in Utah's standing decorum order, but then the order denying bond. That is all. Like, there is not a damn thing. So it's making any speculation on what might be going on very hard to figure out. I just don't.
Hi, Mommy.
Hi.
Mommy, it's this.
Oof. Yeah. Okay.
Hello?
And on that note, hold on. Hold on, baby.
Hello?
You all crack me up.
Hello?
Can you, Angel? Can we
Hello?
I have nothing further for you. Can I talk? Can I talk?
No.
No. Okay. Yeah, here comes the boss. Hey, Angel, we need to see where we can redirect to. Whoa, 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 whoa. Hold on. Hold on. Who is any girl? You think this is so funny? This is so funny, huh? I can't type because I don't have hands. I was trying to see if there was anybody I could send you guys to. But oh, Grandma's house. Words on stream. Are you okay? Did you hit your toe? Oh my goodness. So we're gonna head over to Grandma's house. I don't know. Go tell her I said hi. Hopefully this. Well, let's check again. Whoa, whoa, whoa. Whoa, 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 whoa. You're sinking. All right. All right, guys. Looks like there is nobody actually live. That stream didn't look like it was actually on. But y'all have a great day, and I will see you guys on the next one. And I'll see you around the tubes. Bye, guys. You want to say bye? Bye, guys.